Hello, everyone. My name is Jason Hanford. I'm a partner at Chartwell Law, and I'm coming to you today with my partner, Mary Wagner, from our Philadelphia office. And we're here to talk about something that we haven't talked about yet on our series of videos, which is uh, third-party settlement agreements, the right to offset future payment of workers' compensation benefits in Pennsylvania following a third-party settlement. So unlike many of our prior videos, we're not talking today about coronavirus. We're not talking about COVID-19 or any of those things. We're talking about a specific new case, new decision in Pennsylvania relative to third-party settlement agreement and workers' compensation liens, which I think our Pennsylvania workers' compensation clients at least will find very interesting and probably helpful for some of their claims. So let me start by introducing my partner, Mary Wagner. Mary, can you say hello to everybody?
Hi, everybody. Hope you're staying safe out there.
Yeah, and I want to echo that as well. I hope everybody's doing okay. Some time has passed since we started doing these videos, so hopefully everybody's still safe and healthy. And as we begin to track back towards, getting back into the office and getting back to work for those who didn't have to work during this time period, and we're certainly thankful to those people. As I always say for these videos, if you have any comments, any questions, you can reach out to us on social media. You can make funny, hilarious comments on the social media pages. You can certainly email Mary or myself, or you can go to chartwelllaw.com and look up any contacts that you need there. There's lots of information on this topic. There's information on coronavirus. There's anything you might need, but we're always available to answer any real or hypothetical questions that you might have for us. And as I always say with the videos, we're not providing any specific legal advice to you through these videos. We're just talking about something that's an interesting topic, specifically today in Pennsylvania workers' compensation. And if you go out and do something silly based on what we say on a video, we can't be held responsible for that. But if you have any legal questions for us specifically, please reach out to us. So without any further ado, Mary, I think we can get what we're talking about initially is what happens in Pennsylvania when a claimant settles a work injury and, well, they settle a third-party case and they still have an open work injury. So I think just to set the table a little bit, historically, Section 319 of the Pennsylvania Workers' Compensation Act would control. And for our viewers who aren't familiar, Section 319 established the lien right for the Pennsylvania Workers' Compensation carrier or the employer. That's a workers' compensation lien right. So if you as the carrier or employer have paid a certain amount of money up until the date of the third-party settlement, then that establishes your lien right through Section 319. And Mary, what we always did prior to the Whitmoyer case, which we're going to talk about in a minute, was we would tabulate the numbers. We'd come up with the third-party settlement amount. We'd come up with the cost of the settlement, and we'd come up with what our client's lien was. We'd plug them into the third-party settlement agreement, and then we'd get the client their net lien, which is the chunk of money they get that day. And then, Mary, they'd start taking offsets against ongoing payments of wage loss and medical benefits, right?
Yeah, and I would just interject that we're always under a huge amount of pressure from the third-party attorneys to compromise the lien in some way so that to maximize the claimant's recovery in both workers' compensation and in the third-party case. And so negotiations regarding whether or not the employer should waive any portion of the lien are a central theme in settling both the workers' compensation case and the third-party case, which happened in the situation we're going to discuss. We mediated the workers' compensation case along with the third-party case to obtain a global settlement.
Yeah, and what Mary's talking about, and really what we wanted to start with was, again, stepping back. What we're saying is, if I'm an injured worker and I settle a third-party case, so I have a claim against the building owner, and I also have my ongoing workers' compensation claim against my employer, then my employer gets some sort of reimbursement for that. And in 2018, the Pennsylvania Supreme Court issued the Whitmoyer decision, which I think most of our clients are familiar with. Mary, you and I were familiar with, which really kind of spun that on its head. It kind of changed the status quo, as it were, in addressing third-party settlements in the workers' compensation realm. Can you explain that, Mary? How did Whitmoyer change the way we approach these things?
And we should note that the decision disturbed years of prior Commonwealth Court precedent, and There really was a surprise when the decision came out. But Whitmore decided that they used a statutory construction analysis, and what they said was that Section 319 applied only to indemnity payments or periodic installments of compensation, and it was not, the statute did not intend to apply to ongoing medical benefits. And that was certainly a surprise to everyone.
Yeah, and this was, I think you'd agree, Mary, this was a pretty big deal because it really impacted how there was a good collection of claims that were out there that were already subject to third-party settlement agreements where the carriers were already offsetting not just wage loss payments to the claimant, but also medical payments. And everything kind of ground to a halt. And we got a lot of questions from our clients, how do we respond to this? Articles were written, hairs were pulled and heads were rubbed and everybody got really concerned. And I think everybody kind of dealt with this in different ways. And in one of your ways, Mary, was you had a claimant's attorney file a review petition seeking to set aside an existing third-party settlement agreement and stop the offset of medical benefits. And can you explain, and that's what we're here to talk about today, can you explain to everybody what happened in your case?
I just wanted to just give a brief discussion of the case itself. It was a 2010 injury. It was a young man, chronic pain issues, huge medical bills. He was granted Social Security disability in his 20s. So he was receiving workers' compensation, and there was a third-party lawsuit against one of the other construction companies involved in the injury. We entered into a long mediation and eventually settled his workers' compensation case for a substantial amount of money. And in doing so, it was agreed, the employer waived the settlement amount. Let's say hypothetically it was $200,000. So that $200,000 was not going to be considered as part of a lien. So that's a substantial compromise.
Mary, I think as our viewers would recognize then when they, I think sometimes we get tripped up by the word waived. I know every time we go in comp court and somebody has a CNR, they talk about waiving their rights and everybody in the room gets confused. What are we talking about waiving? I think when we say they waived the $200,000 lien right, that means that in your situation, the claimant got that $200,000 in pocket from the third-party settlement monies that were already available. Is that?
That is correct.
Okay.
And so in 2016, the workers' compensation judge approved the compromise and release agreement. The agreement itself mentioned the subrogation rights. And eventually, a couple of months later, the claimant settled his third-party case for a substantial amount of money, which exceeded the employer's lien. And all parties entered into the third-party settlement agreement, which indicated that the employer would recoup the remainder of its lien during the grace period and pay only 29% of ongoing medical benefits. And in that situation, usually the claimant stops treating because it's not an easy thing procedurally for an employer to, or for a provider to get 70% of the money from the claimant and then 30% from the employer. So by entering into this third-party settlement agreement, essentially the parties were able to settle the claimant's the portion of the medical claim without having to get an MSA. Am I making sense?
Yeah, it sounds like the claimant he still had the right, he or she still had the right to continue with workers' compensation medical treatment. It was just unlikely in that scenario that they would, because if they did, they'd have to figure out how to pay 71% of the repriced amount of, for instance, a physical therapy bill, which is always a pain for our clients, let alone for an injured worker. So I think I understand where you're coming from there. Mm-hmm. Just so we're clear procedurally, was your third-party settlement agreement signed, and was it submitted through WICAS or to the judge, or what did you do with the act?
It was signed. It was sent. It was uploaded to WICAS. And I should also note that in addition, to giving up the right to the $200,000 of the CNR, the settlement amount. The employer did waive, I believe it was around $52,000 additionally to get the claimant more money in the third-party recovery. So everything continued like this through 2016 until Whitmore was decided in June of 2018. Thereafter, the claimant's attorney filed a review petition indicating that the Whitmore decision voided our third-party settlement agreement, and the workers' compensation judge agreed and granted the review petition, thereby ending the employer's right to recoup the additional monies during the grace period.
So the judge effectively set aside the executed third-party settlement agreement.
She did.
On the basis of the holding from Whitmore, which said that the reference to installment payments going forward after a third-party settlement references only wage loss payments. Was that the judge?
That is correct. So
stop there. You appealed this to the workers' compensation?
I did. And I basically used a common sense argument indicating that the parties are entitled to the certainty of a contractual agreement, and I likened a third-party agreement to a contractual settlement, which it was. I said all parties bargained for concessions to make both settlements go through, and I argued that that Whitmore should not apply to the particular case because it was different. In Whitmore, 13 years or so had passed before the employer decided to exercise its right to subrogation. In this case, it was always the parties always intended that the subrogation rights would remain, and what the Workers' Compensation Appeal Board said was that that they saw no reason to invalidate the otherwise valid contractual agreement in this particular situation, and they said that they decided that Whitmore did not. The Whitmore case was not decided on constitutional issues. It was decided on statutory interpretation. And the appeal board's interpretation was that Whitmore should not be applied in this particular situation.
So you won.
We won, yeah.
So the board reversed the judge. The third-party settlement agreement, I guess, in theory, comes back in the window, if that's the terminology we're using. And your client, for the time being, until a new appeal is filed to the Commonwealth Court or something else happens, again, has that right to offset any medical bills that they have. Let me ask you, Mary, one of the things I recall from Whitmore was that the Whitmore defendant and the claimant didn't actually have a third-party settlement agreement in that case. Is that accurate?
I believe that one was drafted but not signed.
Do you think that was important? I don't know if that was argued specifically before the appeal board in your case, but that's a distinction because you had an executed third-party settlement agreement that showed you had negotiated and come up with these numbers. That was definitely
what the Supreme Court looked at. And I should say that that was definitely what they looked at. In this situation, and the fact that 13 years had elapsed and the employer had continued to pay medical bills.
And you're still within the appeal period for your your board decision, right?
We are. The claimant's attorney is not certain whether an appeal is appropriate in this particular situation because I have to say that after the third-party settlement agreement was uploaded to WICAS, we never saw another medical bill.
Yeah, and I think like we said, that does happen a lot. Unfortunately, it doesn't happen often. And I do have some clients that are paying a prorated amount. And I think what happens in some of those instances is the medical provider maybe doesn't get the money from the claimant, the 70% or whatever it is in your case, and then that becomes an issue between the claimant and the medical provider. But I know this was a big deal for a lot of our clients. So I guess the reason I wanted to talk about this, why I thought it would make a good video is moving forward for clients, other clients out there, or other cases out there, other claims out there, if they have a signed, executed third-party settlement agreement that predated Whitmoyer, of course, because I think everybody changed the approach. I think they actually changed the form. I think they changed the Bureau form after Whitmoyer. If you have a party settlement from before Whitmoyer that was signed
the date of Whitmoyer is June 19th of 2018.
Yeah, so June 18th and before, should you go back and look at those claims and say, hey, maybe if we're not taking the offset for medical payments, maybe we should consider it? Would you recommend that to your clients?
Yes, absolutely.
And have you heard from other clients that are dealing with this?
Not yet, not during the COVID crisis, but I'm sure that that it will be an issue that we'll take a look at in other cases, of course.
Yeah, I think it is. It's a little bit of a nuanced area of Pennsylvania workers' compensation law. Of course, it's not coronavirus. It's not something that's affecting the world, but I think it's an important decision. And I know when Whitmoyer came out, it was seen as sort of a shift in the sands. And I know a lot of clients said, well, I already negotiated this. I did this because, as we discussed, a lot of third-party settlement agreements, something is given up. There's something that's compromised with regard to the lien to sort of makes things happen. And when you do that, you're giving that something up with the expectation of, okay, here's the amount I'm going to offset going forward. So I think this could be a helpful decision for our clients, and to an extent, and we've talked about this offline. I don't know if the mailman's there or something. You got your doorbell going.
7 o'clock.
I think to an extent it could be helpful in settling claims, because as we talked about, a lot of times when the third-party settlement is taking place, it's a good juncture to try to close out the comp claim too. And I think this will probably provide a little bit more certainty when we're talking about, is it medical, is it future wage loss that we're taking into account when we're calculating, future exposure in the context of a third-party settlement. So was there anything we didn't talk about that you wanted to talk about, Mary, on this subject?
No, I think we've covered it.
Well, I hope you're doing well. And thanks.
Well.
And if anybody has any questions, if you have any questions on the specific case, obviously reach out to Mary. Her contact information is on the website, probably with the video here somewhere. If you have any questions about the issue in general, you can certainly talk to any of our Chartwell attorneys in Pennsylvania, or if you have an issue in another state, look them up as well. And again, we hope everybody's doing well. And we'll
just remind you that we're working remotely and we're available for any questions that you might have.
We are, yes. This is not what our offices look like. I'm in my my study, so to speak, and Mary's also in her house. So
at the dining room table.
So we're always available, whether by email or phone, or if you want to get on video and chat with us. So we hope.
Yes. Not that we know how to do this, certainly.
Exactly. All right. Take care, everybody. Thank you.